We are continuing from the lecture 17 and this is lecture 18. We at the end of lecture 17, we talked about the case where transaction cost is zero. If you took the lecture 17 a while ago, I hope you would go back to this example where there are physics professor and engineering professor. The example is water power theory and water car. Okay. The conclusion is, as usual, the transaction cost is zero, whether the judge or legal system define the patent broadly or narrowly wouldn't matter. In the end, they would negotiate and the water power theory would be discovered and water car would be made. And always the cost is 10 plus 20, 30, and the revenue would be 50, so net profit would be 20 for the society. Things will change when the transaction cost is not zero anymore, so they cannot negotiate. I'm gonna assume that the transaction cost is very big and negotiation is not possible. Or we are gonna think about what kind of transaction cost would be involved when it's defined broadly and narrowly. As you know, in the previous lecture, when the legal system defined the patent broadly, the first inventor who invented the pioneering invention, water power in this case, would get the patent of water car as well. Okay? So, Kate will get all the profit if the water car would be invented. The problem is, the physics professor Kate discovered water power theory, and she really wants someone to invent water car. Okay? But it's not going to be very easy to find out because, the water car is not invented. So, think about the engineering department of Yonsei University. There are 250 professors out there, even in one university, Yonsei, and it would be very difficult to find out who has the skill and ability to use the Professor Kate's theory, water power theory, into the commercial application water car. So finding out Jane, who can do it, the only person who can apply this water power theory, is not an easy task. Let's focus on that. So how can it be found? However, Kate, who should make the water power theory first, has something to believe on, because when she found out water power theory by investing $10 of her own money, and probably she will publish and she will definitely patent it at the patent office. And when you publish your idea, when you got patent, anybody who are interested in making something, they check the academic journals or they check the patent office every week whether something new came out. So it's not going to be very difficult for Jane to find out there are someone named Kate, and the Professor Kate discovered water power theory by reading the academic journals or checking the patent record. So when you do that, what will happen? If negotiation to be happened, Okay, so this is when negotiation is possible. Jane will approach Kate. Jane will approach Kate and ask, I think you invented water power theory, and can I make water car using that after paying you some royalty? Okay? This negotiation might be costly, the transaction cost. However, thinking that finding out the person, in this case Kate and Jane, who can do this job is the most difficult thing here. Finding out your negotiation partner who has the skill to make water power theory and water car. Broad definition has advantage because the first mover who the pioneering invention, the inventor Kate, would do it, believing that once she does that, whoever do the commercial application next should come to her. Okay, so that's how would it work when the transaction cost is bigger than zero and the patent is defined broadly. What about the narrow definition? The narrow definition is a little bit different. If you go back, when the Kate discovered water power, and if Jane, engineering professor Jane, read that and get to know water power theory, she does not have to pay anything to Kate. She just make water car by investing $20 and get 50, so net profit 30 will go to Jane, while Kate will just invest and kind of waste $10 from her point of view. So in this case, Kate has the pioneering inventor has no incentive to do it first. So the task would be on Jane, who would profit from it. So Jane should find out Kate, who can discover the water power theory, and tell her, okay, I will pay you to do the research and find out water power theory. Unless Jane offer Kate first, Kate will never voluntarily do that, because if Kate do that without discussing with Jane, Kate will just lose money of $10. But this is much more difficult than, so what this means, finding a Jane, for Jane to find Kate is much more difficult than for Kate to find Jane. Why? For Kate to find Jane, Kate will publish her discovery first. So every engineer would know that it is Kate who find out water power theory. Then probably Jane will approach Kate. What about the other way? If Jane has to find Kate and encourage her to do the research on water power theory, Kate hasn't done it yet. So how can you find out a physics professor out of tens of thousands of physics professors who can do this? So find out someone who already published a paper is much easier than find out someone who can do the research and who can publish in the future. Therefore, if you ask me, the narrow definition makes this process much more difficult. So in this case, our example, broad definition has much smaller transaction cost compared to the narrow definition, where the engineering professor should find out the physics professor before the physics professor publish anything. And of course, the reason is, if the physics professor publish first, the engineering professor doesn't have to pay, so physics professor will never do it without meeting the engineering professor. But transaction cost is not zero means finding out the right person is far from each job. Okay? So the recommendation in this case is define the patent broadly. Even though in the example of mine, the defining patent broadly so that the pioneering inventor get all the profit, but that cannot be generalized all the time. Why? Think about this. In previous example, I assumed that the water power theory has zero value while the water car has $50 value. But what if the water power theory by the physics professor Kate itself has a $15 value? Then it is different. It would be a different story, because the Professor Kate, the cost of finding out water power theory is $10. So if she can get $15, she will do it because she can get $5 profit. Of course, she hoped that she can get the water car profit from water car also, but even without the profit of water car, Professor Kate, the physics professor, would do it because 15 minus 10, she can get $5 profit at least. So in this case, narrow rule, defining the patent narrowly is also fine. Actually, it is better. Why? Because once Kate is defined narrowly and Kate invent the pioneering invention of water power theory, then read it in the patent office or academic journal, the engineering professor Jane can use the water power theory and make the water car. In this process, there's just no need for Kate and Jane to negotiate. Okay? Kate just independently announced the water power theory, and Jane just read it and do it without talking to Kate. Jane has no incentive talking to Kate because she can make the water car and she can get her own patent because the patent is narrowly defined. Okay? And she doesn't want to pay anything to Kate because she wants to make as much money as possible. So, what's the difference between the previous case, this case? In the previous case, the physics professor Kate's invention, water power theory, has no value. Here, the water power theory has a $15 value, which is bigger than the cost of R&D $10. So, water power theory itself, in this example, we call it has a stand-alone value, which means without commercial application, the pioneering invention itself is profitable. So when the pioneering invention itself is profitable, has commercial value, it's better to define it narrowly. Because if you define it broadly, then Kate and Jane should negotiate. During that process, there would be a transaction cost occurred. On the other hand, if the standalone value exists for the pioneering invention, the first invention would be made independently, and second invention commercial application would be made independently. There is no need for negotiation. Actually, there would not be any negotiation. So therefore, we got same result without the transaction cost. So, in conclusion, when there is a pioneering invention and commercial application in that order needed to invent something, if the pioneering invention has a standalone value, is self-profitable, narrow rule is better. On the other hand, if the pioneering invention does not have a standalone value, broad rule is better. Okay, it's a little bit complicated logic, but I think you are smart enough to understand. In the case you are puzzled a little bit, please listen to this lecture and the previous lecture again. I'm sure that you will soon realize that. Okay, in reality, this consequential invention, something, the pioneering invention, and then the commercial application, makes a big headache. Have you heard about James Watt? Yeah, he lived 200 years ago. He's a very famous inventor, one of the most famous inventor. Many people think he invented the steam engine. Boo boo, you know that? So he actually is the leading engineer for the industrial revolution in Britain 200 years ago. I found out that James Watt is not really the inventor of the steam engine, the first inventor. It's more like he is an improver of it. Prior to James Watt, everybody knows that the steam engine uses steam to move things. So you boil some water and the water expand and go somewhere with a very high speed and move something. That is how the steam engine works. But once you boil the water and move something, you have to keep doing that repeatedly. So before James Watt, what people do is you boil the water gets hot, steam gets out and move something, and then you cool the water, okay? Because it can expand forever, you cool it and expand it, cool it and expand it, something like that. The problem is, while you are doing that, the cooling, once you cool the water, like, the water was like 100 degree, and then you cool it to like a 60 degree, and you boil it again to 100 degree. So it takes a lot of coal, a lot of heat to do that over and over again. Because like heating something that is like 95 degree to 100, heating something that is 60 degree to 100, there's a big difference. What James Watt did was, why should we cool the water? We just keep pushing the hot steam into the engine so that we do not, and get the steam out of that. So we keep doing, and recycling the steam so that you don't have to boil the cold water from zero. Okay, so you steam it at 100 degree, the steam came back and it became water like 90 degree. You boil it again, so you just boil it from 90 to 100 every time, instead boiling from 50 degree to 100 every time. Something like that. I'm not an engineer, I don't fully understand it, but that saved a lot of energy. So before James Watt, you need tons of coals in your locomotive steam engine to go just 1 kilometer. Now, with the same coal and things, you can go like 7-8 kilometers. So it's much more efficient. Anyway, he is a great engineer, no doubt about that. But James Watt did all this in his 30s or something, when he was young. Then he lived a long life. But after improving this steam engine, he never did the science again. What he did, according to my investigation, he just sued everyone. Even though James Watt improved the steam engine, there's a younger engineer who has another idea to improve James Watt engine. But James Watt said, no. I'm the guy who have the patent monopoly power on steam engine. So if you improve anything, I'm the pioneering inventor. If you improve anything, that's mine, not yours. Because anything about steam engine is mine. And the judge acknowledged that. So James Watt keeps suing everybody who has a new invention. So what will happen? The younger engineers who has an idea to improve James Watt engine wouldn't do that, because if they do it, James Watt sue, they will get no money. What they devote their life to make improvement will become James Watt patent and his money. So we are admiring James Watt for his great invention, but on the other hand, because of James Watt is the person who improved the steam engine greatly, but at the same time, James Watt is the person who prevent the improvement of the steam engine after that. Okay, so when James Watt died, then the patent disappeared. Then at that point, the steam engine has improved again a lot. So James Watt used his patent to block any improvement on the steam engine. So acknowledging the new invention is one thing. And I mentioned that if you do that too much, spreading the new idea around is one problem. Another problem is that guy has an incentive to block any further improvement by suing the consequent inventions. So now the economists and maybe legal lawyers and the law school professors are puzzled whether it's really good to protect somebody's new idea, because the new idea would, if we protect the new idea, that would prevent actually continuously new idea coming up because of the suing. Okay. So patent, some people think we do not need patent. Look at the Coca-Cola. Coca-Cola has no patent at all. They hate patent because when you get a patent, you have to reveal publicly how do you make Coca-Cola. Okay, then if the patent is for 20 years, after 20 years, everybody can make Coca-Cola. Coca-Cola choose not to do that. Rather, they keep the secret. So I heard the Coca-Cola is a secret ingredient, like Kung Fu Panda. In Kung Fu Panda, there's no secret, but Coca-Cola has it. So only the royal family, very high people know the secret ingredients. So the normal Coca-Cola people do not know it. When they go home at night, the owner family came in and they poured the secret ingredients. So nobody knows how to do it. So that is why the secrecy might, if possible, might be better than the patent. And somebody point out that, look at the professors, they write the book and hardly any of them make money out of it. So the inventors and writers, they are not really the person who want to get huge money. They are just enjoy inventing, enjoy writing. Okay, so, but if we give them a patent, all of a sudden, they are going to sue everybody to protect their patent. So maybe it's not necessary. I don't really buy that because I'm writing books, but I want to make money, even though 2 out of 3 times I don't make any money. But anyway, so there is an opinion like that. And if you look at the weather forecast, if you have invented a machine which forecasts the weather correctly, are you going to patent it? Is that the only way you can make money? No. If you know the weather, then you can make money various times. I mean, you can work for the army when there is a war. The weather is very important. Like, or you wanna sell ice cream, and if you know that tomorrow it's gonna be chilly and nobody will eat ice cream, you can reduce the ice cream today. So this information on weather helps business a lot. So instead of patenting it, you can use it for the business. Actually, as an economist, I predict one of the most important thing in economics in the future would be predicting the time of death of everyone. Because there's a lot of waste because people A think, oh, I'm going to live until 70. I will die around 70 years old. So he saved enough money to continue until 70, but he's lucky. He lived until 90. But that would be a disaster because around 70 years old, he spent all the money. For the next 20 years, he survives with no money. That's a tragedy. He would say, oh, if I knew my life would be until 90, I would have saved more money. On the other hand, somebody think he's going to live until 90, but die 70. But then he said, oh my God, if I knew I die so early, I would spend more money, eat more delicious things, travel around more. Oh, I leave this huge money, but I don't enjoy. I just work and I die. So these things, if any medical doctor invent this thing, that will help the managing asset area a lot. Briefly mentioning the other thing, in intellectual property, not only there's a patent right, there's a copyright and trademark. Copyright is books and music. Interestingly, the copyright continues after the author and composer death. So if I write a book, then nobody can copy my book, not only until my death, but in Korea, probably 50 years of my death and 70 years of my death if I'm an American. Okay? So actually, if your father do something, music or book, your mother, he or she dies, for the next 50 or 70 years, you can collect the money out of it. Okay? But not more than that because of tracing cost, which means when I write a book, I am obliged to check maybe the past 100 years, somebody wrote something and I might copy it, violate copyright. But if I'm obliged to check 1,000, 2,000 years, that's too much burden for the writer or composer. So the law said, okay, just check the recent years. Who is more credible, president of university or high school student? Somebody asks you to, oh, please, can I borrow $1 million from you? Oh, a lot of money. Or, okay, not $1 million, $10,000. Still a lot of money. But if that is president of university, Yonsei University, I said, okay, because I know that he's a famous person. If he does not pay me back $10,000, he would be in serious problem. But if he's a high school student, I don't trust him. He will take away my $10,000. I ask him, give me back. He says, oh, no, I have no reputation. So the president of Yonsei University has a reputation. High school student doesn't. So you have more trust to the person with the reputation. Why? It's the trademark. You buy a sneaker, Nike sneaker, and just no-name sneaker, which do you trust more? Nike want to cheat you, but if Nike cheat you, you go on TV and newspaper and Nike would be embarrassed. Then Nike would lose more money, much more money because he cheated, like the president of university. On the other hand, no-name sneaker, if they cheat on quality and they have nothing to lose, like the high school students. So the government protect the trademark. The name Samsung, Hyundai, the famous names, Microsoft, people cannot use that. If someone used that, then they would be punished. That is trademark. Thank you.